So good morning, everyone. This is the second day of our Croatian Girona workshop on errors in legal operation and notification. And the first presentation today is by Professor Ivana Tucak from the University of Osijek. More or less, about emotional argumentation. Thank you, Ivana, to be here. And the floor is yours.
Thank you for the invitation and the opportunity to participate in this event. But actually, I don't know, do you hear me? Because I don't have a powerful voice, it's okay, okay? And because the language, English is not my first language, so but I will try to do my best. So this is the structure of my paper. First, actually the aim of this paper is descriptive. It is to provide an overview of the influence of emotions on law and legal decision making. The paper is divided in three main parts. First, the complex relationship between law and emotions and legal scholarship is explored. The second part of the paper analyzes the understanding of emotional argumentation, primarily in the work The Logic of Legal Argumentation, Multimodal Perspectives by the Slovenian author Marko Novak. The last part of the paper explores the significance of emotions in constitutional interpretation, popular discourse on constitutional rights in Western liberal countries, especially in the United States, in the last decades, as Alexander Loendorf points out, is no longer just this interpretation competitive, aggressive, and mired in bad faith, the interpretation. We are witnessing a political polarization that engenders existing democratic institutions. Loendorf calls it constitutional amateurism as the confrontation of moral disagreements with constitutional rights grievances. In pluralistic societies, misunderstanding about constitutional rights are inevitable. Most rights are not absolute and depend on context. There are different views about the nature of emotions, which have returned to the spotlight. Over the past few decades, the diversity of phenomena encompassed by the word emotion has become the subject of numerous philosophy and affective science studies. According to Andrea Scarantino and Ronald de Sousa, this is the quotation, theories of emotions typically conceive of emotions as a subject phenomenologically salient responses to significant events and as capable of triggering distinctive bodily changes and behaviors. End of quotations. Emotions have a long history, having been the subject of analysis since ancient times under various terms: passion, sentiment, affection, affect, disturbance, movement, and so on. The term emotion only began to be used in English in the mid-17th century as a translation of the French term. So my focus in this paper will be on the role of emotions in legal scholarship. The significance of emotions in legal studies diminished dramatically in the period following the Enlightenment, the French and the American revolutions, and the rise of legal positivism. During this time, a clear divide emerged between reason and emotions, leading to a legal tradition that regard legal reasoning as a cognitive process primarily influenced by professional training. This separation fostered the belief that emotional responses could significantly disrupt legal decision making. In legal theory, a dominant position is occupied what Maroney calls a caricatured view of emotion. Reason and emotions are viewed separately as if they exist in an oppositional relationship to one another. The involvement of emotions in reasoning is seen as a troubling external nuisance, and law is viewed, according to Sayo, as a mechanism that should remove this problem. Law becomes a subject of scientific research, a scientific discipline. Laws are deduced from legal principles to be applied to specific cases. Furthermore, judges detached and rational approach when making decisions should protect them from political pressures and the influence that sympathies they felt towards one of the litigants can have on their decision making. Emotions are viewed as a judicial vice. According to Marko Novak, an ideal judge has been portrayed as a sober logomachy who is capable of an absolute, objective, and rational judgment by withstanding all the attempts of his or her emotions to influence the judgment. This was the quotation. We are discussing the impartial judge model, which Moroni refers to as the persistent cultural script of judicial dispassion. This approach to judicial power emerged in the mid-17th century, particularly in the work of Thomas Hobbes, who depicted the ideal judge as someone free from negative emotions, such as fear, anger, and hatred, as well as positive ones like love and compassion. Nevertheless, this model does not accurately reflect reality. As judges are still human beings, subject to emotions, even when performing their function. This necessitates exploring a legitimate role for emotions, even when performing their function. The ongoing distinction between reason and emotion, which is still prevalent in the field of law today, is also scientifically unfounded. Advances in neuroscience have revealed significant connections between emotions and logical thinking. Legal scholars and policymakers must brace themselves for new insights into human decision making. Contemporary neuroscience will influence the legal landscape, as mentioned by Sayo, by reshaping perceptions of free will and responsibility. Sayo notes that new social science research generally seeks to rehabilitate emotion. Scholars' research is based on cognitive models, for example, that consider emotions equal partners in human judgment. Abrams and Karen emphasize three movements that today question the narrow definition of rationality, commonly held by lawyers and legal scholars: law and emotion movement, behavioral law in economics, and law in neuroscience. Research on the law and emotions movement is vital for my purpose. Today, it constitutes a dynamic set of scientific papers and other works that incorporates various interdisciplinary approaches to analyzing emotions that influence law and legal decision-making. This movement is based on the claim that emotions significantly influence legal thinking and decision-making. The movement originated from feminist legal theory and critical legal studies, evolving into an interdisciplinary field of research on different affective reactions. As Moroni points out, this is the quotation, law and emotion interact on multiple levels. Events that call for a legal response, violent crime, property, theft and damage, environmental destruction and infringements on personal liberty, just to name a few, evoke powerful emotional responses among those immediately affected and in the public at large. The people who implement those legal responses, policy, legislators, lawyers, judges, and jurors, experience emotions of their own. This is the end of quotation. Legal scholars and philosophers are increasingly exploring scientific research from evolutionary biology, for example, neuroscience and psychology, which affirms the cognitive component in the structure of emotions. For example, Martha Nussbaum follows this path in her significant book, Heroes of Thought, The Intelligence of Emotions. This interdisciplinary approach challenges the traditional legal perspective that views emotion as irrational, instinctive, mysterious, stubborn, and uncontrollable, contrary to reason. The fundamental premise is that emotion contains and rely on evaluative thoughts. In this view, emotions are considered belief about the state of the world. Moreover, neuroscientists and psychologists have provided compelling evidence that, as was emphasized by Manrique, without a normal capacity for emotion, human beings become incapable of practical reason. This is the interpretation. The law and emotions movement aim to convince jurists that the emotions permeate the law. Rather than focusing on broad concept of emotional responses, proponents of this movement focus on specific emotions, such as revenge, shame, anger, and compassion. Negative emotions like anger and revenge have long been an important topic in criminal law, which is not unique for other areas of law. Questions such as whether a defendant acted in the heat of passion or shown remorse are explored in this movement. When sentencing in criminal proceedings, judges routinely express anger because of the harm a perpetrator has caused to individuals and the community. This also creates the impression among the injured parties that, as was emphasized in Mahoney, they are within the judge's zone of care. Now I come to the part where I will discuss the arguments of Marko Novak. Marko Novak explores how emotional arguments can function as grounds in legal argumentation. The validity of an argument is contingent on the domain in which it operates. Law is a field of argumentation that has specific rules. Novak identifies two categories of typical emotional arguments. Emotional argument 1, dialectic, and emotional argument 2, rhetorical. Novak presents departures from the idea that emotions should not be special grounds or premises in legal arguments, specifically in the areas of legislation and alternative dispute resolution. I will now focus on legislative procedure. Applying the law in a narrow sense implies that courts or other legal bodies apply law to facts in legal proceedings. Courts follow the deductive pattern of subsuming facts under legal norms. Facts and legal norms are premises in a deductive syllogistic argument. In a formal and a normative sense, in this typical example of the application of law, it is considered that emotions cannot be an independent premise. But what about the creation of laws or constitutional norms? The inductive element plays a key role in the legislative process. When laws or constitutions are passed in Parliament, emotions are acknowledged as legal or institutional facts. Emotions play a role in legal argument in dialectical manner, according to Novak. Novak references Andreas Sayer's book, Constitutional Sentiment, which challenges, as noted by Matthias Malman in the foreword of the book, the traditional answer to the problem of the foundations of constitutionalism. Sayer analyzes the claim that the foundation of constitutional legal systems must derive from the permanent material or rational thought. The foundation of constitutional legal systems is shaped by reason as modernity triumphs over irrational emotionalism. The development of human rights-based constitutionalism is one of the most important dimensions of the broader process of rationalization characteristic of modernity. Some challenges this prevailing view emphasizing that the Constitution is not only a product of reason, but it also arises from individual and collective social emotions. This second category of emotion is even, according to Sion, more important than the first. Emotions thus play a key role in shaping constitutional orders, with fear and anger being particularly prominent. The neutrality of law in modern constitutional systems arose from the fear of cruelty and oppression. This neutrality, Malmann emphasizes, is a central mechanism for shaping a society where human rights are respected, a society with no room for destructive emotions. According to Sion, modernity has reduced emotions to second-class citizenship. The constitutional system and the judiciary are regularly considered institutions that, in their effort to remove emotions from the public sphere, improve the efficiency of human affairs. The American Bill of Rights and the French Declaration of the Rights of Man and Citizen established a rational framework for human rights that became dominant in the Western Hemisphere. Laws aim to create, this is interpretation of Sion, a sterile mental environment. They are considered misleading and therefore unacceptable. Legal decisions should be exclusively cognitive, deductive, and subject to rational control. But Sion points out the problem is that this ignores the extensive body of laws that recognize and do not suppress emotions. Laws sometimes selectively protect emotions, as can be seen in the example of religious freedom. Sion uses instead of emotion, the 18th century term sentiment. His aim was to highlight the crucial place that social emotions have in the constitutional order. In the Middle Ages, the view that specific emotions influence human behavior prevailed, but this was abandoned and the focus shifted to the individual self-interest as the primary source of explanation for his or her behavior. Modern law represents an attempt to rationalize emotions and, according to Sion, has been relatively successful. However, the distinction between reason and emotion is oversimplified. The goal of the Enlightenment was not to suppress emotions, but to promote self-control, which allows for the appropriate expression of feelings. The Enlightenment wanted to free individuals from superstition, according to Sion, believing that emotion did not threaten reason as much as fanatism. Sion devoted a special chapter of his book to discussing fear as a fundamental social experience in the adoption of constitution. Even today, when parliamentary representatives pass laws, they are guided by interests and emotions. For example, fear may influence their decisions when enacting anti-terrorism legislation or public health legislation, such as provisions related to combating contagious diseases. Along these lines, American constitutional theorist Jamal Green claims that emotional thinking is crucial when making laws, since emotions are a key component of public morality. I concur with Sion that the Constitution must be a subject of multidisciplinary research, otherwise we are left, these are the Sion words, with an impoverished view of the Constitution as a mere collection of pompous words. However, the legislative procedure is primarily political and not legal, according to, as emphasized by Noah. Unlike law, which many still use as an area where emotions are not welcome or where only rational and logical thinking is acceptable, politics provide an institutional process for the fulfillment or channeling of desire. Politics is seen as emotional, as emotional and instinct-driven acting. And now something about the category that Marko Novak explained about emotional expressions of legal argument. The institutional framework of the judiciary does not already space, Novak points out, for emotional argument 1. Emotional reasons cannot represent separate premises in a legal argument. Emotional grounds are not valid in law. None of them raises a question regarding emotional argument 2. Lawyers regularly appeal to emotions in courtrooms. Similarly, judges who write dissenting opinions frequently use emotions to convey their differing viewpoints from the majority. Ancient legal rhetoricians were aware of the importance of emotions, Nolan points out, and this importance varies depending on the different phases of trials. The type of emotions that lawyers appeal to also depends on the audience they are addressing. In court proceedings conducted before judges of lower courts, emotions are directed at them, and lawyers attempt to influence their decisions through emotional appeals. Conversely, lower court judges aim to sway the audience, consisting of higher court judges. Supreme Court justices, in making their decisions, seek to convince the general public of the validity of their reasoning. Since logical argumentation predominates today, Novak emphasizes that emotions are used rhetorically rather than dialectically in the judicial context. And now I came to the last part of my paper, and that is the use of emotions in constitutional interpretation. As was noticed by Alexander Landorf in his paper Rights Talk and Constitutional Emotivism, published in the Canadian Journal of Law and Jurisprudence last year, constitutional rights are one of the youngest types of rights because they appeared in the first written constitutions in the middle of the 18th century. Their role in today's social and political life surpasses the role of other rights, some of which have existed since antiquity. Pathetic argument, pathos, is one of the three modes of persuasion based on participants' emotions. In Aristotle's classic work, there is a logical argument logos, which relies on deductive or inductive reasoning, and an ethical argument ethos, which is based on the speaker's character. Pathetic arguments are often present in constitutional law. To fully grasp the concept of pathetic argument, emphasized Jamal Green, it is crucial to understand it as a mode of persuasion, rather than archetype of argument, such as historical or textual analysis. Pathos is not solely a personal emotion, it also encompasses a significant public aspect relying on the common human feelings and reactions shaped by the interpretation of collective visual culture. According to Sion, the quotation, I will highlight those features of emotions which are crucial to social reputations. Emotions are not momentarily personal feelings, habits to be forgotten as soon as the pain goes away. Emotion scholarship has demonstrated that emotions contain social information, contribute to social coordination, and are culturally regulated. This is the end of the quotation. Scholarly research emphasizing the role of emotions in judgment has received support from prominent members of American judicial profession. In this context, the text of the renowned U.S. Supreme Court Justice William Brennan, Reason, Passion, and the Progress of Law is significant. According to Mermuni, this lecture of Justice Brennan initiated the law and emotion movement by highlighting it as a real danger to due process principles, transforming law into an instrument of a sterile bureaucracy. According to Brennan, his interpretation, it is my thesis that the interplay of forces, this internal dialogue of reason and passion, does not taint the judicial process, but is in fact central to its vitality. This is particularly true, I think, in constitutional interpretation, the end of quotation. Brennan is also not talking about emotions, but about passion. And he also, in that paper, gave a definition of passion. This is again the quotation. By passion, I mean the range of emotional and intuitive responses to a given set of facts or arguments, responses which often speak into our consciousness far ahead of the lumbering syllogism of reason. The end of quotation. Brennan highlights the case of Goldberg versus Kelly as a pivotal moment that initiated a modern due process evolution in American constitutional law. In this case, the court ruled that social assistance recipients have the right to be heard before their benefits can be terminated. Brennan argues that the decision in this case demonstrates, this is a quotation, an expression of the importance of passion in governmental conduct in the sense of attention to the concrete human realities at stake, the end of quotation. He believes that by validating emotions in constitutional interpretation, Goldberg versus Kelly corrects a system that has been misguided by abstract rationality. However, Maruni criticizes Brennan, noting that while Brennan recognized the significance of emotions, he did not clearly define the characteristics that attribute value to them. According to Maruni, these characteristics include, this is quotation, emotions reflect reason, enable reason, and are educable, end quotation. This contemporary understanding of emotions resonates with the views held by the early 20th century representatives of American legal realism, who argued that judicial emotions are not only inevitable but valuable. This is a quotation of Maruni, that emotions are valuable does not of course mean that they are invariably reliable guides. No one attempts to make the case, nor could one make such a case while taking seriously the cognitive theory of emotions, as emotions can reflect inaccurate beliefs or bad values, the end of quotation. A significant example of emotions in constitutional law is also this US Supreme Court decision in Gonzalez versus Carhart, which upheld the legal ban on partial birth abortions. The court justified its decision by emphasizing post-abortion regret, highlighting the feelings of regret that women may experience after having an abortion. This case illustrates the use of specific emotional regret as a ground for constitutional ruling. This is the quotation from that judgment in Gonzalez versus Carhart. It is self-evident that a mother who comes to regret her choice to abort must struggle with grief, more anguish and sorrow, more profound when she learns, only after the event, what she once did not know, that she allowed a doctor to pierce the skull and vacuum the fast-developing brain of her unborn child, a child assuming the human form. The end of the quotation from this judgment. As was noticed in the abortion debate, two issues are most prevalent, and they are full of emotions. The first issues concern the status of the fetus. It is often defined as a central question of whether a fetus can be granted legal subjectivity. For a right, it primarily defines who is considered the holder of rights. It is necessary to determine the threshold of personhood status, but when it comes to acceptable ranges of answers and determining the point at which one becomes a person, there are numerous disagreements. At the same time, the moment of birth is an evident phenomenon, has enormous cultural implications in almost all societies. The term person is thus used to denote the difference between the fact that someone merely genetically belongs to the human race, fetus, and they are holders of rights. None of abortion rights advocates denying fetuses the status also no opponents of giving fetus legal subjectivity actually doubts that fetuses genetically belong to the human race. They only don't recognize them. They only don't give the status of legal entity. For them, belonging to the human species represent a biological category, ethically irrelevant for determining the moral status of an individual. That was emphasized by Kate Priestley and Fletcher. And the term person denotes a category of being that possess a certain kind of moral status, usually elaborated in terms of interests or rights, and provides a set of normative implications about how it is morally acceptable to treat such person. If the fetus is recognized as a person with the right to life, abortion is then a criminal offense or murder. However, if the fetus is not recognized as a person, not only as a being that genetically belongs to the human race, the protection of mother's reproductive rights takes precedence and abortion should be legally permissible. But in recent decades, it was just in this case, Gonzalez versus Carhart, the discourse, the debate about abortion rights is not focused on the status of the fetus, but has been increasingly focused on the arguments that protect women. These arguments emphasize the need to protect women from the consequences of their own choices and have gained traction in discussions about the permissibility of abortion, often in opposition to traditional views that prioritize the fetus' right to life. Kate Priestley attributes the shift to a strategic decision by religious groups opposed to abortion. As a result, states have enacted laws aimed at safeguarding women from the potential harmful effects of abortion. Such laws include mandatory counseling, waiting periods, and ultrasounds. Additionally, other decisions by the Supreme Court also highlight the complexity of the abortion choice. For this instance, Justice Stevens referred to the decision to have an abortion as traumatic. In his concurring opinion, in the famous case Planned Parenthood versus Casey. However, the authors argue that this perception about regret is unfounded. Extensive empirical studies show that the majority of women view their decision to have an abortion as correct and do not characterize it as difficult choice even over time. Terry Maroney, in his article, Emotional Common Sense as Constitutional Law, criticized this use of emotions in constitutional interpretation, especially the decision in the case of Gonzalez versus Carhart. This interpretation, the court was proudly folk psychologically representing its observation about women's emotional experience as self-evident interpretation. Maroney criticized this approach when making decisions. The courts must not rely on what he refers to as emotional common sense. And this is also the definition of this term. According to Maroney, emotional common sense is what one unreflectively thinks she knows about emotions. A species of common sense It seems obvious and universal to its holder, but this appearance is misleading. This is the end of the quotation. It is noteworthy to mention Jamal Green's criticism regarding the inconsistency of one of the most significant rhetoricians in the American Supreme Court, the late Justice Antonin Scalia, in making your case, The Art of Persuading Judges, which he co-authored with Brian Garner. Scalia rejected the notion that lawyers should use emotional appeals to judges. Instead, he and his co-author argued that they should appeal to judges' sense of justice. However, Green contends that Justice Scalia was inconsistent on this point. In the mentioned case, Planned Parenthood of Southeastern Pennsylvania versus Casey, which addressed the constitutionality of abortion rights, the Supreme Court chose not to overturn the famous case Roe versus Wade. In the Roe versus Wade from 1973, the U.S. Supreme Court adopted the idea of the women's right to free choice regarding the termination of pregnancy. In Casey, the so-called precedent of precedent, the court confirmed the primary perception of women's right to abortion expressed in Roe. What both decisions have in common is that they provide a woman with the right to abortion at least until the moment of the viability of the fetus, and that they do not recognize the fetus as a legal entity. In this case, Justice Scalia utilized an emotional argument. He concluded his partial concurrence by describing a portrait of seemingly tormented Justice Roger Taney on display in the Casperson room of the Harvard Law School Library. Scalia argued that the Casey decision on the constitutionality of the right to abortion was akin to the Dred Scott versus Sanford, in which the majority, led by Taney, affirmed the constitutional right to own slaves. Green concludes that the pathetic arguments place a prominent role in constitutional law. However, it is more accurately described as a mode of persuasion rather than a constitutional argument. This is no different from Noah's previously mentioned arguments. Additionally, we should consider the role of emotions in selecting judges. Is there a place for emotions in this process? U.S. President Obama faced considerable criticism when he nominated Sonia Sotomayor to the Supreme Court. He argued that her capacity for empathy made her suitable for the role on the court. Are emotions such as empathy and compassion important in the work of judges? I want to conclude my presentation with the concept of constitutional empathism. Alexander Neuendorf bases this concept primarily on the works of Mary Ann Blanton, on her book Rights Talk, the Empowerment of Political Scholars, and Jamal Green, How Rights Went Wrong, Why Our Obsession with Rights is Tearing America Apart. He opposes the subsuming of politics and moral misunderstandings among the citizens about important social issues in the language of law. This is the definition of constitutional empathism. According to Neuendorf, this is the quotation, constitutional empathism occurs when rights claims are made that are not based upon any reasonable or plausible instance of rights grievance, nor based in a history of recognized rights violations, nor loosely derived from reference to any controlling precedent. In a sentence, there are highly emotional reactions mirrored in a constitutional mythos that encourages willfully misinformed ideas on what constitutional rights are and do for citizens living in a constitutional democracy. The end of quotation. Neuendorf places his concept primarily within the framework of American constitutional law. The American Constitution of 1787 is almost impossible to change in Congress, which has given the Supreme Court a prominent place in the constitutional order. The most significant amendment to the Constitution was, according to American legal historian Jim McCullough, in 1971. The Constitution provides for a process of amendment or the inclusion of new rights through constitutional amendments. However, this is a highly complex process. Throughout American history, more than 10,000 amendments have come before Congress, and only 27 have succeeded in changing the Constitution. For example, proposals for amendments to ban abortion or protect a woman's right to abortion as constitutional right began to arrive in the early 1970s. However, their number did not decrease. It was actually increased significantly after 1973 and the Roe decision. Thus, emotive language is used to discuss right in constitutional context. Landorf called this constitutional emotivist right. So I'll conclude this with his words. Actually, rights become a medium for channeling the emotions of the rights claimant, for it is easier to shut down a hard conversation with a right invocation. It is easier to claim one has a right to do something than it is to express that one is upset or offended by some rule or requirement. An invitation and the end of my presentation.
Thank you very much. Although he could not be here today, I would like to begin by thanking Victor Garcia de Zaguirre for the invitation to participate in this workshop, and it's a great pleasure to discuss your paper, Ivana. As we heard in the presentation, the paper addressed central issues about the connection between law and emotions. This, as you show, is a vast and intricate domain, so my remarks should be taken as exploratory reflections rather than definite claims. Since I'm not familiar also with Marco Novak's work, I will limit my observation to your arguments, without presuming whether Novak himself would endorse the view presented. The paper raises a great number of ideas, and I will do my best to provide a clear and constructive feedback, despite the difficulty of selecting which aspect to address. My aim, as I said, is to contribute to the paper's development, should my comments prove useful to you, of course. I will begin with a general observation before moving on to more specific claims found in your text. As a general matter, I think that the connection between law and emotion is, I believe, even broader and more paradoxical than the paper suggests. The paradox lies in the dual nature of emotions. On the one hand, they can offer reasons for action, and reason explanations that make behavior intelligible. And on the other hand, they can also exert a causal influence that bypasses reflective deliberation altogether. It's easy to see this paradoxical feature in criminal law. For instance, usually we assess that an action deserves less reproach if intense emotions are swept us away, but at the same time, other emotion or the same emotion in other contexts being equally intense aggravate responsibility. This is what happens with the excuse of provocation or the hate crimes in law. Other examples of the connection between law and emotions, for instance, can be seen in shame or fear. Shame or fear can explain, for instance, why certain norms are effective. Yet, apart from rare exceptions, we generally agree that shame-based punishment are unacceptable. Similarly, we may believe that proper emotions education could help prevent certain crimes or assist in the reintegration of offenders. But at the same time, we are wary of grounding criminal responsibility on persons' emotional dispositions or character trait. I think that these examples suffice, to highlight the extent and complexity of the law and emotional nexus. To add of what you have said, and discussing the point. Turning now to the article itself, if I can understood correctly, you advance 4 main claims. 5 now, because there is a difference in your decision than in the paper, but at least 4. First, that the motions are a source of certain legal norms. The second is that the motions function as explanatory reasons in judicial decisions. Third, that the motions serve as justificatory reasons in such decisions. And the fourth is that the motions of third parties may be taken into account as grounds for judicial ruling. And well, we could add the link between constitutional law and emotivism. Although these 2 topics are important, I'm not going to say anything about this. Regarding the first claim, I agree with you about the central role of emotions as generators of certain legal norms. For instance, the so-called Seminario law, that is an anti-discriminatory law in Chile, was the result of the indignation for the brutal killing of Daniel Zamudio by 2 neo-Nazis. But the same could be said of the new rules against immigrants promoted by far-right wing groups such as Trump and his henchmen, who uses fear to promote freedom detention. The important challenge is to analyze whether emotions should be considered as a reason or ground to have some specific rule. Depending on your answer, disagreement about this subject will be a normative disagreement about the role that the emotions should or should not play in the creation of legal rules. I will now focus on the second and the third claim, the role of emotion as explanatory and justificatory reasons in judicial decision making. Although you frame the paper as a primary descriptive, there seems to be an implicit critical stance toward those who downplay the role of emotions in adjudication, suggesting that such views are reductive. On page 1 and 2, you mention that, quoting you, the involvement of emotions in reasoning is seen as troubling external nuisance, and law is viewed as a mechanism that should remove this problem. However, you also argue that these models, and I quote, does not accurately reflect reality as judges are still human beings subject to emotions, even when performing their functions. My point is that there appears to be a conflating between 2 distinct claims. First, that emotions do influence in judicial decision making, a descriptive claim, and second, that emotions ought to be considered justificatory reasons for such decisions. This is a normative claim. One can accept the former with rejecting the latter. Why rejecting the latter? That is, I can have a very nuanced theory about how emotions influence human action, but deny that some emotions should be present for a decision to be justified. Furthermore, the reason I present to demonstrate the influence of emotions on our behavior do not provide ground for the first claim. The thesis regarding emotions and justificatory reasons is normative. It pertains to what we deem appropriate conditions for incorporation into judicial decisions. We can assess these ideas as correct or incorrect, but not as true or false. Conversely, this thesis that seeks to explain how emotions impact our behavior can be either true or false. Saying that there are different dimensions does not deny the connection between explanatory and justificatory reasons. For instance, there is a great discussion of whether an agent must have acted for a particular justificatory reason for an action to be justified, but which we don't need to deal with this problem here, either you want or me. The main idea that I am suggesting here could be stated like this: emotion can explain both right and wrong behavior, but pointing out the role of emotions in explaining right decisions is different from justifying that decision. This particular point is what seems to be tangled in paper. Another point now is that I think that you need to engage in some notion of emotion. You implicitly seem to assume that emotion always produces explanations based on reasons, but if that's the case, you have trouble to understanding the paradoxical aspect of emotions I mentioned above. That is, you can explain the instances where emotions drive us as causal forces. Moreover, to be a fine reconstruction of the way emotions could influence causally judicial decisions, they can do it in different ways. First, the influence that emotions generate on our beliefs about the case. For instance, indignation over a type of crime. There have been proven that, for instance, with mock jurors, that if disgust is present, we more easily find the defendant guilty than innocent. Okay, this is the emotion influence our beliefs. The second is the distortion that can be produced by the emotions generated by factors external to the case. That is, for instance, the judge's fury or sadness due to a family event. And the third, the general biases that influence decision making. Whether such influence can be successfully eliminated or controlled is an open question, but it is one that your argument must confront. Personally, I remain skeptical about our capacity to fully grapple these effects. But even if we assume that emotions only provide us to act based on reasons, you seem to assume that emotions always function by providing adequate reasons. Still, they can be both adequate or defective reasons. For example, consider a judge whose feelings of disgust toward homosexuality lead him to downplay the seriousness of a homophobic assault. Regarding now the normative claim, literature about emotion as justificatory reasons usually focus on three kinds of strategies. And as Daniel Gonzalez here points out, each one has their particular problems. These strategies are: first, emotions are closely related to moral values and principles, either because they create them or because they allow us to understand them. Second, emotions are guide for the interpretation of legal norms, the proof of facts, the qualification of particular cases under general norms, and the fair decision, because they allow us to understand the relevant circumstances of the case to be judged. And the third one, emotions are necessary condition for the justification of a decision. That is, a practical decision is incomplete if the emotions that should accompany it are missing. You may need to choose one of the strategies and face and answer their problems. Finally, if emotions are to serve as justificatory reasons, it will be helpful to clarify their basis role. Are there to be a supplement to an existing justificatory framework, or are they being offered as a replacement or alternative? Given this shift toward a virtual ethical model of adjudication, this point deserves further elaboration, as it would strengthen the normative dimension of your paper. There is much more that could be said about Tucak text, and I'm aware that my own remarks have barely scratched the surface. Still, I hope they serve to stimulate discussion and give the author the opportunity to further develop and clarify their position. Thank you.